SwayamPrabha. Digital India. Educated India.
Very warm greetings to all of you, dear students. Once again, I welcome you all in the lecture of Law of Banking and Negotiable Instruments. I am Dr. Raju Maji, Assistant Professor, Faculty of Law, Banaras Hindu University. Now, in this lecture, we will discuss about the banker and its business in India. As we have already discussed that what do you mean by the bank, but again I would like to discuss in details that what is a bank and how the banking is performing its business and what business can be performed by the bankers. Although I have decided that to discuss in this two lecture, the first lecture I will discuss very simply that what are the banking business, how it business can be done, and in the second lecture which is related with that, that is the how the banking functions are, we can say, regulated. So, we will discuss in that second lecture. So, in this lecture, as a banker and its business in India, it is very important. In what respect it is very important? Because as a scholars of the banking law, you must know about that what are the banking business, which business can be done by the banker, and at the same time we will have to see that whether the banking sector can engage themselves in other business, that is a question mark for you. So, by keeping all the things, I have decided to discuss in this lecture, that is in the four heads, I will try to make you clear that what do you mean by the banker and what is the banking business. So, the first, there are four questions which I have read, and we will try to get the answer of these four questions in this lecture. The first questions which I have raised, who is a banker? That is very important. The second questions which I have raised, what is banking business? And the third questions which I have raised, how banking business can be commenced in India. And the fourth thing which I have mentioned, that how the business of banking can be managed. But as my question, that the second, third and the fourth questions, that will again we will elaborate when we will discuss about the functions of the Reserve Bank of India or powers of the Reserve Bank of India, which I will discuss in the next lecture, that is related with that. But it is very important to discuss the few things in this part. Now, let me tell you, as I have told you, that the banker, which is unique in its nature and it is different from the other financial institutions. Let me briefly recall the certain things which we have already discussed in our previous lectures also, but again I would like to reiterate before you that we must know the banker. And the second thing which I would like to mention here, that we must know that how it is distinguished from the financial institution. My dear students, as earlier I have mentioned in my previous lecture, that the banker is playing a very significant role, very important role, very pivotal role we can say for the development of any nation. As we in the present time, we cannot imagine that anyone can live in this country or any part of the world that without the help of the banking. So, in that way we find that the banking plays a very significant role in our day-to-day life. Now, for example, if you will see in the present time that you are accessing your banking systems, or you can say the banking transactions through your mobile phone. So, there is no need to go before the bank. And at the same time you will see that recently that the Reserve Bank of India also talking about, and he introduced, that is the digital coin. That is very important things. And as far as that when we are talking about the digital coin, then we will have to, if we will see the some part, or if we go a little bit back, then you will find that how the banking started its function. The banking started its functions in a very traditional way, and that was only to accept the deposit from the public, and that what the deposit he has received from the public, he will invest it in what that will be invested and lend, and whenever the customers demand, the liability lies towards the banker under the Negotiable Instruments Act of section 31 of the Act, that he has to return that money. And the mode of payment, or you can say mode of demand, has been we have already discussed. Now, the second question, that is what is the banking business, we will discuss in details. And as far as concerned the banking business, as I have told you, that is given under section 6 of the Banking Regulations Act. We will see that what are the banking business has been described. But a very beautiful thing is that at the same time we find that the central government has a power that he can include any kind of business within ambit of the banking business, and that power has been conferred under section 1 clause O of the section 6 of the Banking Regulations Act. That is very important aspect of that. We will see in detail that part. But apart from that, the things which has been given under section 6 subsection 1 of the Act, nowadays the banking the function is extended beyond that, and the reason behind that, from time to time we experience that the government is expecting more from the banking sector. That is a very important thing, and in that way it is a very relevant to discuss here that what is the bank and what are its business, and how that business is commenced in India, and how the business of banking can be managed. So, I am coming to the first one, that let us try to understand that who can be called as a banker. As I have already mentioned earlier also, that again I would like to make you clear here that the banking, before reading the section 5 clause B of the Banking Regulations Act, that is one of the statutory definitions which is given under that. That is not only the definitions we can say that describe that what do you mean by the bank, it describes what are the functions of the bank, it describes how the banker will discharge that liability. Everything is given in a very simple statement. So, the banking company is defined as a company which transacts the business of banking in India. The Banking Regulations Act 1949 defines the business of banking by stating the essential functions of a banker. It also states the various other business a banking company may be engaged in and prohibits certain businesses to be performed by it. So, at the very beginning, as I have told you that there are the certain business which has been described under section 6 of the Act. But the section 6 which is talking about, that is not confined or that is not limited. Why the reason behind it? Because the central government has the power, he can expand or he can add certain business or he can delete certain business from that list. That power has been conferred to the central government. So, as when we are reading these definitions, the term banking as defined under clause C of clause B of the Banking Regulations Act 1949. Clause C is talking about the definitions of the company. What do you mean by the banking company? The banking company who is registered for the purpose of a banking business in our country within the parameter of the Companies Act 2013 we have right now. Earlier we had the Companies Act 1956, but it was refilled and new act was enacted for the purpose of the formation of any company. So, the banking company also registered under the Companies Act 2013. So, clause B of section 5 of Banking Regulations Act define the term banking, and it says accepting for the purpose of lending or investment of deposits of money from the public, repayable in demand or otherwise, and withdrawable by check, draft or otherwise. So, I have already mentioned before you that as far as concerned to be called any institutions as a banker, it is very important that he must accept the deposits from the public. When he is accepting the deposit from the public, it is also very important at the same time that he has to invest that money, he has to lend that money. If he is keeping that money and he is not engaged himself for investing or lending that money, that cannot be called that the institutions is doing the banking business. That is very important as far as concerned, that to call any institutions that is the banker, he has to accept the deposits from the public, and whatever the money he receives from the public, that money can be treated as their own money, and that money can be that can be invested somewhere, that can be given to lend to somewhere. That is very important. So, as far as concerned, that when we are trying to understand that, we can understand this section 5 clause B in that way. What are the essential features of these definitions that can be described in the two way? The one, a banking company must perform both the essential functions while accepting the deposits and lending or investing the same. If the purpose of accepting of deposits is not to lend or invest, the business will not be called banking business. As I have mentioned here, that when we are reading, we are trying to understand the definitions which are given under section 5 clause B of the Banking Regulations Act. It is very important. What is that? To accept the deposits, it is very important, but that is not sufficient. What is the next one? That the deposit which has been accepted by the banking company, he must invest that money or he must lend that money. If the banking company is not investing or not lending for the purpose of that, we cannot say that any institutions under the definitions of the banking. And the second is very important, that is phrase, deposit of money from the public is significant. The bankers accept deposits of money and not of anything else. The word public implies that a banker accepts deposits from anyone who offers his or her money for such purpose. The banker, however, can refuse to open an account in the name of the person who is considered as undesirable persons, for example, a thief, robber, etc. So, in that way, that the banker's capacity is a different way, the bankers have the right to accept deposits from the public, but these indigenous, or you can say the others, those who are engaged in such kind of, you can say, banking business, they do not have a right to engage themselves, or they do not have a right to accept deposits. But as my concern, as I have told you, that it is very important to discuss before proceeding further, that what is the difference between the banking sector and the financial institutions. Although one thing which I like to mention you, that when we have discussed the power and functions of the Reserve Bank of India, we will discuss that in details. But in this moment, just I like to mention here that the financial institutions is entirely different from the banking. The financial institution then cannot use the name bank, banker or banking words with their name. They cannot use it. They are financial, like the Tata Finance, we can say the other company, Reliance Finance, they are using the finance, they are not a banker. The reason behind it, because they are not carrying the banking business. Now, the question is that what is the banking business? That the first questions which will come before us, that before proceed, it is very necessary to clear it. The financial institutions, as I have told you, they do not have a right to accept deposits from the public. But again, you can raise the question that they are accepting deposits from the public. It is all right. They are accepting deposits from the public, but in what they are accepting their deposits from the public with the certain conditions which you are calling, that either they are accepting in case of the recurring deposits, or they are accepting deposits in terms of the any kinds of the mutual fund schemes, or they are accepting that money in form of, you can say, the term deposit or the fixed deposit, what we are calling. If we will discuss all the things that the mutual or the recurring, or you can say the fixed or the term deposit, then you will find that it is from the very beginning they are entering themselves with the conditions. But as my concern, that when we are talking about the banker who is engaged themselves by accepting deposits from the public, that he is accepting deposits in the different form, and these two different forms are there, that only the bankers can have the right to accept deposits from the public in terms of the saving bank account. And the second one is that only the bankers can have that right to accept deposits from the public in terms of the current account. There is the savings account, the current account, that cannot be opened by or in that form unless and until there are any institutions will covered under the banking. They are not entitled to do that, or they are not entitled to accept deposits in terms of the savings account or in terms of the second one, that is the current account. So, that is the first difference between the financial institutions and the we can say that the banker. The second thing which is distinguish between these two, as I have told you, when the bankers is opening, then he is offering, when the bankers is opening an account for his customer, then he is offering what? The check facilities. He is offering the card facilities. So these things cannot be done, but at the same time you will find that some sort of, because the card what we are talking about, that is also offering by the others like this for their own transaction, but that is not transactions with the banker. For their own facility that can be granted, that can be attached with your accounts. That's the different issue. But the check facility can be issued by the banker to its customers only, because they have the capacity to accept public deposits in terms of the saving account or in terms of the current account, but the other financial institution. But both whether the one hand we are talking about the bank, or in the other hand when we are talking about the financial institutions, all these institutions are regulated by the Reserve Bank of India. That there is no doubt about it. They are not free from it. All are regulated by the Reserve Bank of India. So the third things which I like to mention here, that the definitions also specify the time and mode of withdrawal of deposits. The deposited money should be repayable to the depositor on demand made by the latter, or according to the agreement reached between the two parties. As far as concerned, as I have told you, like the financial institutions, the banking sector or the banking company is also accepting deposits in terms of, you can say, the term deposits or the fixed deposit. Nowadays, the bankers is also opening an account in terms of the recurring deposit. When we are talking about the recurring deposit, the term deposit, as I have told you that it is from the very first time, or from when they are entering into it, it entered into the conditions. But I find concerned that when the customer is opening an account and a savings account or the current account, there is no any kind of preconditions. What is that? The persons have a right to demand it, and the bankers is distinguished from the other financial institutions in that perspective also, that the bankers is bound to return the public money or their customers' demand whenever the customers demand it. But as far as concerned, as I have told you, the whenever the customers demand means it doesn't demand in the road, he has to demand. But nowadays if you see, then the demand can be made through the fulfilled through the ATM or electronic devices. But if anything happened or if it is not complied, the banker cannot be held liable for it. Banker can be held as a trader, not as a banker. As a banker, only when you are rushing or when we are visiting the bank, and if the bank is not or you can say not honoring your order, that we can say that it is denial of the bank. In remaining cases, that the bankers, as I have told you, that the bankers is extending the various kind of services, and if any kind of, you can say, the deficiency if you find in that service, that will not discharged by the banker. That is a part of the, when the banker is acting as a trader, the banker is not acting as a banker. So in that we find that the bankers is the persons who is accepting deposits from the public. At the same time, the money which he accepted in form of the deposit, he is investing or lending for the purpose of the bank. And the third thing is that the banker's obligations is to return money. How he will return? That he will return on demand. So as I have mentioned here, the essential features of banking business is that the banker doesn't refund the money on his own accord, even if the period for which it was deposited expires. So most of the time you will find that the bankers will not inform you that your money is lying in your account. It is your duty that if you have a money, if you do not wish to continue the relationship which you have developed earlier with the banker, you can close it. You can say the ended the relationship with the banker, and that can be ended by filing an application. The very immediately the bankers will, by taking all sorts of, you can say that if you don't have any kind of the overdrawn, if you have not taken any kind of the advances from the bank, the bankers is bound to close your account as soon as you are showing your willingness that you don't want to continue the relationship with the banker. So just simply you will have to file an application before the banking authority, and the banking will close your account as immediately, and he will return all the money which is credited in your account. There is no problem. It is the contractual relationship, and the relationship can ended at any moment, any time. It depends on the wish of the customer. But on the other hand, the bankers cannot exercise such kind of rights. The banker, when he is willing to not continue relationship with any of the persons, then he has to give prior notice that there may be some of the regions that he has to mention the regions that we do not want to continue a relationship with you by giving a proper notice that can be closed, and it is compulsion that the bankers has to return all the money which is available in the name of customers account. But at the same time, as I have told you, that the bankers is not means it is not the duty to inform its customers that your money is lying there. What is the responsibility? If any accounts which is not operated by any of the customers, that information will be sent to the Reserve Bank of India by details that the following numbers of accounts, the person's details, that he has not operated his accounts from the last 10 years, and that money will be go before the Reserve Bank of India. There are the very important things which have been mentioned as a banker. As I have told you that everyone we need our identity. So, how any persons can be recognized. Similarly, that how we will distinguish, because there are the many institutions, those who are engaged in, you can say, the some sort of, you can say, the banking business, which may not be called the actual banking business, but the banking sector which he is dealing, they are also involved in that way, like the financial institutions, and some of the institutions, they are doing the you can say the some sort of, you can say, the mutual fund or the life insurance. They are engaged in that way. They are accepting deposits from the public. So, it can be distinguished through that, and that is very important that provisions have been made under section 7 of the Act. Section 7 of the Act, which is talking about that name must be include the word bank, banker, banking. So, any bank who is engaged himself as a banking business, and for the banking business, it is very necessary, which we will discuss, as I have told in the latter part, that is section 22 of the Banking Regulations Act. Section 22 of the Banking Regulations Act, which is talking about granting a license. So, if anyone who is willing to accept or to do the banking business, then he has to obtain a license from the Reserve Bank of India. That is very important. So, in this regard, here I would like to mention one very important thing. The section 7 is very important. Section 7 makes it essential for every company carrying on the business of banking in India to use as a part of its name at least one of the words bank, banker, banking, or banking company. That is very important. And the two aspects is very important. One, that for the public they can easily identify that is a bank, and if there is no the words, if they will find, and if they are accepting the deposits, that means they are not accepting deposits in terms of the savings account or in terms of the current account. They are accepting deposits either in form of any kind of the schemes, or they are accepting in a forms of the recurring deposit or the fixed deposit. So, besides, it prohibits any other company or firm, individual or group of individuals from using any of these words as part of his name. Section 7 was amended in 1983 with the effect that any of these words cannot be used by any such company even in connections with its business. So, it is a very important that section 7 is talking about only and only the banking company can use it, and the banking company means those who are carrying the banking business in India. So, the next questions which we have raised at the very beginning, that what is the banking business? As I have already mentioned with you that there is a long list of the banking business, we will see one by one. And as we have already discussed, as when we have discussed the relationship between the banker and customers, then we find that by extending any source of, you can say, services, the banker relations, what we discussed, the secondary relationship that is developed with the help of these kind of the businesses, because the bankers is empowered to do the such kind of business. So, one very important things which I like to mention here for your kind consideration, that as I have told you that the bankers means that accepting deposits and investing or lending the money. The one is the return on demand, and the demand will be made in a proper way, in a proper form, and the proper form has been described under section 5 clause B of the Banking Regulations Act, where the term banking has been defined, and that is the demand can be made in form of the check, draft or order or otherwise anything which is accepted by the banking practice. Now, the other business permitted for the banking company is the primary business, it is given under the definition itself. But as far as concerned, there apart from that, the banking is not confined to it. But again, I would like to mention here that if the banking is not involved itself in all the business which are described under section 6 of the Act, it doesn't mean the banker cannot do, or the bank that institution cannot be called the banker. But as I have earlier also mentioned, again I am reiterating it, that the choice is not available to any banking company in the present time, because the concept has changed, and that might be the reason from time to time that by exercising power which is given under this clause, the section 6 clause O, that the central government is exercising this power and he is adding some sort of, you can say, the additional business to the banker, which comes under the definitions of section 6 subsection 1 of the Act. So, it said the Banking Regulations Act 1949 specifies other forms of business banking company may engage in. According to section 6, the following business may be undertaken by a banking company. So, here I would like to mention, before reading these provisions before you, it is very important that the banker's main primary business is accept deposit, invest, lend the money and to return on demand. That is the main business of bank. But besides that, the bankers is empowered, you can say, or the banker's choice is available that they can engage in the following business. It is better to say the banker has no choice nowadays, because there is a competition amongst the banking companies and the bankers has to accommodate all kind of, you can say, services which he can engage himself. If failing which, the bankers company, or you can say any of the banking company, they cannot survive in this competitive era. So, let me allow to see what kind of the business which can be transacted by the banking company which is carrying banking business in our country or in India. Clause A says the following functions from a bulk of the bank's activities and are called its main functions. The one is the borrowing, raising or taking of money. That is, as we have already discussed, that the banker has the right to borrow money, the banker has the right to raise the funds, and the banker has the right taking up money from the public. The lending or advancing of money either upon security or without security. Now, the very important aspect which is given, that sometime we will find that the government is taking some of the assurance with the help of, you can say, some sort of schemes which is launched by the government through the banker. At that time we will find that they are not giving any kind of the security, they are not taking any kind of the security from the persons who is borrowing money from there, who is entitled to get the advances or the loans from the banking. For example, the Kisan Vikas Patra, that the Kisan credit card, they are entitled to withdraw the limited extent of money from the banker, they are taking it, and for that purpose they are not giving any kind of the security. That is the purpose, is that the lending or advancing of money either upon security or without security. And most of the time, even the very the nominal account, if you are amount which you are taking in form of the overdrawn from the banker needs some sort of the security. But as I have told you, that there are certain things which we can say that where the banker is not taking any kind of the security. The reason behind it, because it is launched under a scheme which is provided by the government of India or by the state government, whoever may be. The drawing, making, accepting, discounting, buying, selling, collecting and dealing in bills of exchange, hundis, promise notes, coupons, drafts, bill of lading, railway receipt, warrants, debentures, certificates, scripts and other instruments and securities, whether transferable or negotiable or not. So, there is some sort of, you can say, the negotiable instruments as far as we will discuss that part in the when we will discuss the negotiable instruments. But at this moment, just I like to bring some certain few points, because these words which we have used. So these are the means, these are the instruments through which the transactions can be made. So, and it is accepted as a negotiable instruments if the negotiable instruments mean which can be negotiated, and the negotiate means it is a transferable by endorsing. So we have a separate discussion over this, the negotiating, or you can say the endorsement. We will discuss that part there, but here these are very important, that the banking business is engage themselves in any of the drawing, making, accepting, discounting, buying, selling, collecting and dealing in bills of exchange, hundies, promissory note, coupons, drafts, bill of lading, railway receipts, warrants, debentures, certificates, scrips and other instruments and securities, whether transferable or negotiable or not. The next very important thing is the granting and issuing of letters of credit, travelers check and circular notes. Further, it is talking about the buying, selling or dealing in bullion and specie. The next one talking about the buying and selling of the foreign exchange, including foreign banknotes. And further, it is talking about the acquiring, holding, issuing on commission, underwriting and dealing in stock, funds, share, debentures, debenture stock, bonds, securities and investment of all kinds. And further, it is talking about the purchasing and selling of bonds, scrips and other forms of securities on behalf of constituents or others. And further, it is talking about the negotiation of loans and advances. Further, the receiving of all kinds of bonds, scrips or valuables on deposit or for safe custody or otherwise. 11, it is talking about the providing of safe deposit vaults, and further it is talking about the collecting and transmitting of money and securities. Now, these are the main functions which have been given under section 6 clause A of the Act. When we read these provisions, then we find, and mostly what we have discussed, the relationship between the banker and customers, these kind of the functions are delivering by the banking sector, or in other way we can say the bankings are engaged nowadays as a banking business. As I have told you that there is no choices available for the banking business, because due to the concept, due to the concept has been changed, and as far as concerned that there is a competition among the banking companies, as I have already told you. So that's why that every banking company as much as possible, or as many kind of, you can say, the activity they can incorporate within their business, that would be better, or that would be help to, you can say, the survive in the competitive era. Further, clause B is talking about it may act as an agent of the government, local authority or persons and can carry on agency business, but it cannot act as secretary and treasurer of a company. Now, the banking company, that he can act as an agent for any government, the most of the time, as I have told you, because the Reserve Bank, for example, the Reserve Bank is also a bank. So, when he is acting, or when he is directing, or when the governor or the deputy governors, they can be engaged for the purpose of that act, means for they have a right to give some sort of, you can say, the advices to the government. Similarly, these bankers, when he is acting as a banking, they can be appointed as an agent of the government, they can be appointed as an agent of the local authority, or a person can carry on agency business, but it cannot act as secretary and treasurer of a company. Only the two, they cannot be an independent part of that, but they can render their service as an agent, and agent means there is a relationship between the two persons, the agent and principal. So, the principal becomes the government, and he can appoint the banking as an agent for discharging its business. Clause C is talking about it may contract a public and private loans and negotiate and issue the same. That the government, as I have told you, that from time to time some kind of the schemes through which he wished to distribute some sort of, you can say, the assistance to the needy people. That might be to the farmers, or that might be the persons those who are living the below poverty line. So, the such kind of a contract in public and the private loans that can be negotiated and issue the same. The clause D further talking about, it may affect, ensure, guarantee, underwrite, participate in a managing and carrying out any business of estate, municipal or other loans, or of shares, stock, debentures, stock of companies, and may lend money for the purpose of any such issue. Now, that the bankers, as I have told you, that's its very primary functions is lending the money. Anyone who wishes to borrow money from the bank, the bankers can do that. And for the purpose of, as when I have told you that the bankers can act as a guarantor for any persons, the banker can act as an agent for any persons. So, discharging that his assignment, he can do such kind of, you can say, act like they ensure, guarantee, underwrite, participate in managing and carrying out issues of state, municipal or other loans, or of shares, stock, debentures, stock of companies, and may lend money for the purpose of any such issue that can be done. The clause E further talking about, it may carry on and transact every kind of guarantee and indemnity of business, as we have already discussed under the relationship between the bankers, customers, that the bankers and between the customers, the relationship can be developed as a guarantor and guarantee. When the bankers is extending the clause E's services, which is a part of the banking business as far as concerned, section 6 subsection 1 of the Banking Regulations Act, so that he can give the guarantee or indemnity of a business. Clause F, again it is talking about, it may manage, sell and realize any property which may come into its possession in satisfaction of its claims. As far as concerned, the banker cannot engage in other kind of the businesses, as we will see, which is described under section 8 of the Act, which is prohibited. The certain kind of, you can say, the business is prohibited. The banker cannot engage himself. But as far as concerned, that whether the selling of these particular things, it said that he is entitled to do for what? For the realizations of its, you can say, money. So, the clause F is talking about, and that we have seen that there is a relationship between the banker and customer, that is a pawner and pawnee, we have already discussed. And he can exercise, when he is exercising the lien right, as we have told you that any property which retained by the banker in terms of the security, by exercising this power, the pawnee relationship, that he can sell out it. So, that is permissible under clause F. It says it may manage, sell and realize any property which may come into its possession in satisfaction of its claims. As we have already discussed, that the Reserve Bank of India, you can say that it empowers any banking company as a under the contract law. There are many rights which have been conferred, and particularly when we are talking about that the lien right has been conferred and the banker is exercising the general lien right. But in the general lien right, as we have already discussed, that there is no right is granted under the Contract Act as far as concerned to sell out that the things which is in the possession in terms of the bailey or bearer relationship. But at the same time, this it empowers, as I have told you, the bankers is acting as a pawner and pawnee relationship also. So, it can be sell out for what? For the realization of any property which may come into its possession in satisfaction of its claims, because he has claim over it. Clause G further says, it may acquire and hold and deal with any property or any right, title or interest in any such property which may form the security for any loan or advances. Here, as we have already discussed, that the lessee-lessor relationship. The reason behind it, because the clause G is empowering that the banking company can engage in that kind of activities, and it says, let me allow to read out clause G. It says, it may acquire and hold and deal with any property or any right, title or interest in any such property which may form the security for. Further, clause H says, it may undertake and execute trust, as we have already discussed, that the banker have that rights, as at the present time if you will see most of the banking, they are doing or they are acting as a trustee, because the customers, if they have the access money, so they can hand it over to the banker, and the banker will not act as a banker at that time. He will act as the trustee, and as a trustee what he will do, that he will act for the beneficiary, for the benefit of the beneficiary. So the bankers, it is the banking business as far as concerned, that clause H of the section 6 subsection 1. Clause I is talking about, it may undertake the administration of estates as executor, trustee, or otherwise. Under the Banking Regulations Act, we will discuss in details that he can execute or he can have that power, and that can be a part of their, you can say, the banking business. Clause J further it says, it may establish, support, and aid association, institutions, funds, trusts, etc. for the benefits of its present or past employees, and may grant money for charitable purposes. Now, the people are not rushing towards any financial institutions or you can say any institutions, they are not rushing towards the banking. Banker has its own business as far as concerned, that section 6 subsection 1 clause J, and it says that it may help forward for the establishment and support. They can provide the aid for whom, to whom, the associations, the institutions, funds, trusts, etc. for the benefits of its present or past employees, and may grant money for charitable purposes. The banking business, even some extent we can say that either you can say that because it's a company, and the company means the company has to discharge some sort of the corporate social responsibility also. In that way, that it is a part of the banking business, unless and until it will incorporate the part of the banking business, the banker cannot do that because it is restricted under section 8 of the Act. That's why the clause J is talking about the bankers is entitled to engage himself for what it may establish, support, and aid association, institutions, funds, trusts, etc. for the benefits of its present or past employees, and may grant money for charitable purposes. That's very important. Again, I would like to repeat you. Here, this provisions is mentioned under that it's a banking business. The reason behind it, I have told you that section 8 prohibited the things which is not listed under section 6 of the Act. That might be the reason these things is also included under the banking business. And as I have told you, the banking can extend their support and aid for whom, with whom, that for the association, the institutions, funds, the trusts, and he can also extend their support for the benefits of its present or the past employees, and may grant money for charitable purposes. That's very important. Clause K is also very important. It is talking about it may acquire, construct, and maintain any building for its own purposes. As we know that the banking company, whenever it is, you can say, formed under the Companies Act, as far as concerned, it is registered in the Companies Act, it becomes a corporate body. Being a corporate body, it requires some sort of, you can say, the assets. And he can acquire or he can possess the certain things, then yes, the answer is in an affirmative form, and that is yes, he can have that right, that he can possess some sort of the property for its own use, and it's a part of the banking business, and he can expend money on it. And clause K is empowering it because it is the banking business. It may acquire, construct, and maintain any building for its own purpose. Clause L, again further it is talking about that it may sell, improve, manage, develop, exchange, lease, mortgage, dispose of all or any part of the property and rights of the economy. When such business is of a nature described in section 6 subsection 1, the things which you have read from clause A to clause L, any kind of the business which is engaged by the other persons, because the financial institutions, they can engage themselves, and suppose they wish to associate with the banking. So, can the banking company extend all this service as a part of its banking business? It's very clearly mentioned under clause M. So, clause M plays a very significant role as far as concerned to associate with the other persons, those who are rendering the services which is given under subsection 1 of section 6. It plays a very significant role. The clause N is again very important. The clause N is talking about it may do all such things which are incidental or conducive to the promotion or advancement of the business of the company. Now, see, if we read the clause N is again I am telling you that it plays a very significant role. In what respect? It is talking about it may do all such things which may incidental or conducive to the promotion or advancement of the business of the company. So, anything which is related with the services which has, or you can say the businesses which has been laid down, or you can say the described under clause A to clause M, for the extent or for anything which is required that might be the incidental or conducive to the promotion or advancement of the business of the company, that can be a part of the banking business as far as concerned clause N subsection 1 of section 6. That is very important provisions which is made, and the banking company in connections with any the business which is rendered under subsection 6 subsection 1 of section 6 of the Banking Regulations Act, that the banking that will come under the definition of a banking business. Now, as earlier I have told you, then again I would like to read out that provisions, that is clause O is very important. I have already mentioned that clause O empowered the central government. The central government may add or may delete. Deletion or you can say the additions provisions power can be exercised by the central government. That particular section empowers, because the central government derogatory cannot do it, or he cannot exercise that rights. So, that is why for the benefit of the country, in the public interest, from time to time the banking company, you can say, that can engage such kind of business when the government felt that because the banking is playing a very significant role in either way, and even after that if they requires that the banking company must do that, the banking company cannot do its business, the choice is not available, because the section 8 of the act which prohibits to do apart from the business which is listed under section 6 subsection 1. So, naturally that if you wish to take the help of the banking, or if the banking must include or indulge all these businesses, then what you will have to do, that the central government must incorporate all the things what the central government is expecting from the banking company, that must be listed under what? That must be listed under the subsection 1 of section 6 of the Banking Regulation Act. Unless and until it is incorporated or it is described under this, it cannot be, the banking company cannot be engaged himself in that business. So, it is a very good provisions which we have made, and as from time to time if the central government felt that we have to engage the banking, the companies in those areas also, they need the support of the banking for the economic growth of the country or prosperity of the nation, the central government can take all these decisions. And some of the very important decisions which are made by the central government, which I like to describe before you. As I have already mentioned before you, that the section 8 prohibits a banking company from engaging directly or indirectly in trading activities and undertaking trading risks. No banking company shall directly or indirectly deal in buying or selling or bartering of goods, or engage in any trade or buy, sell or barter goods for others. A banking company, however, is permitted to do so for the following purpose. What are the purpose? The one which we have already discussed. Again, I would like to reiterate that when the section 8 is prohibiting, but the some extent that can be exercised by the banking company. 1. To realize the securities given to it or held by it for a loan, if need arises for the realizations of the amount lent, which I have already discussed with you. And the second one, it is talking about to buy or sell or barter for others in connections with the bill of exchange received for collection or negotiation, and undertaking the administration of estates as executor, trustee, etc. under subsection 1 of clause 1. So, this section shall not apply to any such business as is specified in pursuance of clause O of section 6 subsection 1, that is to any other form of business which the central government specifies as lawful business of a banking company. So, by exercising that power, there are the new development, or you can say the changes have been made by the central government by exercising that power which is conferred under clause O subsection 1 of section 6 of the Banking Regulations Act. Some of the incidents which or you can say the decisions which has been taken, and with the help of that the banking sector, they entered into that business which I like to mention before you. The new business undertaken by banks. During the recent years, commercial banks have started rendering the following services. The one very important decisions which are taken by exercising the powers of clause O of section 6 subsection 1, that is the banks and the insurance business. The central government has notified insurance as a permissible form of business that could be undertaken by banks under clause O of section 6. Subsequently, in April 2000, the Reserve Bank of India issued guidelines for banks' entry into the insurance business. Now, if you will see, most of the, you can say that the insurance business are done, but as my question that the insurance business is not regulated by the Reserve Bank of India. To regulate the insurance business, there is the separate legislations we have, and the IRDA authority is there that is regulated the insurance business, but the bankers are empowered. So, the Reserve Bank of India issued a guidelines that how the insurance business can be done by the banking companies, because it is empowered by the central government that the banking sector, the banking companies can enter into the insurance business. The second very important things which is again you can say that by exercising the powers of clause O, the central government empowered, or you can say the central government we allowed the banking companies to do the banking business, and that is to buy or sell or barter for others in connections with the bills of exchange, receipt, the receipt and collection or negotiation. But besides that, if you will see that the banks as participants of securities depositories, the banks are eligible to be appointed as participants of the securities depositors set up in India. Several banks are undertaking this function to open demat accounts in their customers and charge fees for maintaining and operating such accounts. Now, through the demat account, it extended the services for its customers that they can buy the sell or the shares, debentures through it, and the bank is promoting, because the bankers is entitled. If you see particularly the private banks, they have are taking very lead role in this particular, but even the other banks are also doing. At the same time, the another kind of the business which is incorporated by the central government, and it permits, you can say, or it allowed to the banking company also to do the business, that is the mutual products. So, several commercial banks have commenced the business of selling mutual funds, products of various mutual funds functioning in India. It is also a fee-based business. So, if you will see, if you rush to the bank, then bank will nowadays they are not very much worried about to opening an account, because at the present time, if you see that we cannot live having a relationship or developing a relationship with them. Under the various schemes, even the persons, those who are living in the below poverty line, where the government is extending some sort of support for them, these kind of, you can say, the support that is also done through the banking sector. So, they must have an account in the bank, otherwise their Manrega, you can say, the wages that will not be issued. To get that or to avail any kind of the government schemes, every kind of you can say the beneficiaries, they must have an account with a particular bank. Sometimes it is assigned by the government itself that in which bank you must have an account, because there must be you can say the association with that bank. It is not mandatory, but sometimes it is asking that you must have an account for what? For the convenience of that, because the bankers is keeping its money with that bank. So, that might be the one reason that sometimes it is asking that you must have an account with that. But as far as concerned, in the present time, you will see this is expanded and that the promotions is taken by the government, you can say that every person must have an account, and if you are continuing whatever may be the form of your account, that it grants, if you are continuing account as far as concerned, as we have seen, then we find that there is the insurance scheme is also launched if you are continuing with that account. The 2 lakh rupees insurance are given to the person, those even those accounts which is operated by the beneficiaries under any particular schemes. So, it is encouraging that you must have an account with the bank, otherwise you are not entitled to avail the any kind of, you can say, the schemes which is or the benefits which is granted by the government. So, as far as concerned that if right now if you go, then the bank will talk about that we have the different kind of the mutual fund schemes. You will have to buy that might be the regular forms, or as I have told you that the bankers is opening the Demat account. Through the Demat account you can exercise that power. Now, the as far as concerned that when we have seen at the end, I would like to recall, or you can say it is my humble submissions as a scholars of the banking law, you must have that. You will have to understand that the 3 sections which you will have to read, section 6, section 7 and section 8, that is very important, because section 6 is talking about these are the business, section 8 is talking about this is prohibited, and at the same time that clause O empowers the central government, that the central government can add any more business, as you have experienced that due to that the banking sectors are involved themselves at the insurance business, the mutual funds business, or any kind of, you can say, things we are expecting in the near future, that we are expecting that the other business will be engaged by the banking company, and the banking company, as we know that now time the wealth management and the investment advisory services also extended. We are hoping that in the near future bank will extend its support for the prosperity of the nations in that way, and it will work with the government in a very well manner. Thank you very much.